and then we'll get started. All right, it looks like we have about 21 people in, and the number stopped climbing, so we will get started. Good morning. Thank you for joining us bright and early on this Wednesday. My name is Jessica, and I'm joined by my colleagues Kathy and Nancy. And we are going to go through a brief presentation about Connecticut paid leave with you. The presentation is being recorded, so you will be able to access it afterwards if you'd like to rewatch it or share it with anyone. And we would ask that if you have any questions, if you can use the QA feature, we will try to answer any questions at the end, but we would prefer you use the QA feature as opposed to the chat feature. So with that, I will share my screen and we can get started. All right. Nancy, Kathy, can you see the screen?
Sure can.
Great, thank you.
Yes.
All right, so today we're going to talk about what small businesses need to know about the differences between FMLA and the Connecticut Paid Leave Act. And we've titled it, "Hey, do you have a minute?" Because we know this is often the phrase you hear when employees might come and knock at your door, typically probably at the end of the day, and ask if you've got some time to talk. And often them needing some time off is the reason. So Kathy and I are going to take the lead on this presentation. My name is Jessica Vargas. I'm the marketing director with Connecticut Paid Leave, and I have been working in communications, broadcast media, and marketing for the past 15 years. I'm a lifelong Connecticut resident with the exception of the 4 years that I spent in Dallas, earning my bachelor's degree in advertising and in Spanish at Southern Methodist University. Kathy, would you like to introduce yourself?
Sure. Thank you, Jessica. Good morning, everyone. Happy Wednesday. My name is Kathy Mihailuk, and I am the benefits process lead here at Connecticut Paid Leave Authority. I came to the authority with over 20 years of HR experience in HR benefits, implementation, and absence management. I received my bachelor's in business administration from Sacred Heart, and a master's in communication arts from the College of New Rochelle. And I have also been a lifelong resident of the state of Connecticut. Thank you.
So here are some of the topics we're going to cover today. Obviously, our main focus is the Connecticut Paid Leave Program, but we also want to talk about FMLA, which refers to the Family and Medical Leave Act, and how it works in conjunction with, and also how it's different than Connecticut Paid Leave. We'll talk about the implementation of both the Connecticut Paid Leave Act and FMLA, and we will leave you with some additional resources for more information, as well as getting to questions and answers. So first, we want to just give you a brief overview of the Paid Leave Authority. So we are a quasi-public agency that oversees the Paid Leave Program, and we have 5 main areas of focus. Outreach and engagement, so making sure that everyone who's impacted by the program knows about it and understands it. Developing the policies and procedures needed to run the program. Establishing the trust fund contribution rate and receiving contributions. I will note that we cannot increase the contribution rate. That's set by statute. So when it says establishing the trust fund contribution rate, we actually cannot increase it. Approving and auditing private plans. That's for those employers who would like to elect to have their own private plan as opposed to participating in the state plan. And lastly, and what's on everyone's mind right now, is administering claims for paid leave benefits. Some key dates throughout the past year or so. So last November, we began registering employers for this program. On January 1st of this year, employers were to begin deducting contributions from their workers through payroll deduction. It's 0.5%. We began accepting private plan applications in February. Quarterly, the contributions are due to the Paid Leave Authority, and there is a 30-day grace period, so that makes the actual due dates April 30th, July 31st, October 31st, and January 31st. Just a week ago on December 1st, we opened our application portal and began to accept applications for paid leave benefits for absences that are happening on or after January 1st. And starting on January 1st, those approved folks will be able to actually start receiving their benefits. Let's talk about who's covered. The Paid Leave Act says that employers who have one or more people working in Connecticut do need to participate in this plan, and that includes nonprofits and private sector employers with a unionized workforce. Now, sole proprietors and self-employed individuals are not required to participate, but they may choose to opt in if they would like to. The only important note is that if they do opt in, they must remain in the plan for at least 3 years. There are some exceptions for folks who are not covered, and that includes employees of the federal government, employees of the state of Connecticut, except as to covered public employees, which I'll discuss on the next slide. Same with municipalities and local or regional boards of education, and non-public elementary or secondary school employees. There are also some exceptions because these people are covered by other laws, and that includes railroad workers, individuals who are employed by the government of another state, employees of sovereign nations, which includes, of course, Foxwoods and Mohegan Sun, employees in interstate commerce who work in Connecticut but live in another state, so that would be truck drivers, and then spouses of active duty military who pay taxes in their home state instead of the state where their spouse is currently deployed. Now, there were a couple mentions of covered public employees. So what that refers to is non-unionized employees of the state of Connecticut. They do have to participate in this program. Unionized employees of the state who collectively bargain to be included would also be covered. And then employees of municipalities and local and regional boards of education. If the unionized employees do collectively bargain to be included, then all employees are included, both union and non-union. And you can see the definition of municipality down below, which is pretty extensive, includes towns, cities, as you would expect, but also tourism districts, flood commissions, and things like that. So we mentioned sole proprietors and independent contractors. So if you pay self-employment taxes as defined by the IRS, you are not an employee, and therefore you are not required to participate in the program. As I mentioned, you can enroll if you choose to do so, and if you do that, you must stay enrolled for at least 3 years. You would contribute the same amount as any other employee, so 0.5% of your self-employment earnings. But if you're a sole proprietor and you also have employees, even if you choose not to opt in for yourself, you do need to deduct the 0.5% from your employees and remit those contributions on their behalf. And then if you receive a W-2, you are considered to be an employee under the law, and you do need to participate. And that's true even if you're the owner or officer of the company. So what happens with the contributions? The contributions are post-tax, and they're based on FICA wages. The contributions are capped at the Social Security contribution limit, which is currently just shy of $143,000. So that means even an employee who makes over $143,000 would not contribute more than the maximum amount, which works out to $714 per year. And the Social Security max is going up to $147,000. So that number will change. So the contributions are collected by employers. They're remitted to the Paid Leave Authority on a quarterly basis. We receive that and we validate the information against other sources of data that we have from other state agencies. We deposit those contributions into the Paid Leave Trust Fund, and that trust fund is managed by the Office of the Treasurer. And then the trust fund is what actually pays out the benefits for people who are approved starting in January. Now we want to talk a little bit about FMLA and how it relates to Connecticut paid leave. So FMLA, many employers are familiar with this, but some smaller employers may not have ever had to deal with this before. So FMLA refers to the Family and Medical Leave Act. And FMLA provides job protection when people take time off of work for qualifying health and family reasons. However, it does not provide any income replacement. FMLA has been around since the 1990s. There's both a federal law and a state of Connecticut law. And both laws, as I mentioned, do state that that leave is unpaid. Employers are able to adopt policies to provide for income replacement. So for example, some businesses will provide paid maternity leave or things like that, but it's not a requirement under this law. And many employers do either require or permit their employees to use their accrual, so their sick leave, their vacation time, etc. But FMLA in Connecticut is changing significantly next month, and it's going to impact far more businesses than it ever has before. And that's why we wanted to talk about it. And we'll get into the changes in just a moment. So starting January 1st, there are some new rules around Connecticut FMLA. There will no longer be any hours worked requirement for eligibility. So currently, there's about, I think, 1,000 hours that a person needs to work for their employer before they're eligible for job protection. That is going away. There will no longer be an hours worked requirement. Job protection currently attaches at 12 months of employment, but that will change and it will attach after 3 months of employment starting in January. The most significant change is that currently Connecticut FMLA only applies to businesses with 75 or more employees. That will become 1 or more employees. So many businesses who have not had to consider job protection under FMLA previously now will need to do that. There are also some expanded reasons for leave, including family violence leave, and an expanded definition of family. And then, of course, in conjunction with the FMLA changes, there's also the Paid Leave Act going into effect. So this just sort of summarizes what I just talked through. Currently, 75 or more employees will change to 1 or more employees. Currently, 12 months of employment with at least 1,000 hours for job protection will change to 3 months with no hours worked requirement. The length of leave is also changing. So currently there are 16 weeks of leave available in a 24-month period, and that will change to up to 12 weeks in a 12-month period. The only note there is that for military caregiver leave, it is 26 weeks of leave, and that is not changing. There will also be an additional 2 weeks of leave for incapacitation during pregnancy that may be available, and that incapacitation does not need to be related to the pregnancy. The employer can also currently require their employees to use all their accrued time, paid time off in order to have income replacement during their leave. That will also be changing. So the employer will be able to require employees to use their accrued PTO, but they will have to allow them to keep up to 2 weeks of accrued PTO. So for example, if someone has 4 weeks of PTO and their doctor tells them that they need to have surgery, they're going to need to go out and they'll need 3 weeks to be out of work for recovery. The employer could require them to use 2 of their 4 weeks, but they would need to allow them to retain the other 2. If the employee said, you know what, I want to use all 4 of my weeks, then that's fine. But the employer cannot compel them to do that. Now, Connecticut paid leave is sort of the flip side, right? So Connecticut paid leave does not provide any job protection, but it does provide income replacement. So we often use the acronym CTPL, and that stands for the Connecticut paid leave, and we use it to refer to the statute itself, the program, and ourselves here at the authority. Again, the important thing to remember is that FMLA and Connecticut paid leave are 2 separate laws, right? So Connecticut paid leave does not provide job protection. Just because someone is able to receive that payment does not necessarily mean that their job is protected. You might also sometimes hear Connecticut paid leave referred to as PFML or paid family and medical leave. Now, what are the reasons that someone can apply for paid leave benefits? And these are also the reasons that they can apply for job protection under FMLA. The first is medical leave, and medical leave is leave that's taken by a worker to either receive treatment for or recover from their own serious health condition. And that can also include serving as an organ or bone marrow donor, as well as pregnancy. Bonding leave is probably the most common leave that most people are familiar with, and that is taking time after a new child enters the home for bonding with that new child. And that child can enter the home through birth, adoption, or foster care. Bonding leave can be taken by both mothers and fathers, and it can be taken anytime during the 12 months after the child's birth or placement in the home. So Even employees who are having babies or adopting or fostering now in 2021 can be eligible for bonding leave in 2022. And bonding leave can also apply in the case of adoption or foster care to those pre-placement or pre-adoption activities. Caregiver leave is leave that's taken by an employee to care for a family member who's experiencing a serious health condition. So that could be taking them to perhaps chemotherapy appointments or just providing psychological care and comfort for a family member that's experiencing a serious health condition. As I mentioned, Connecticut has a provision for family violence leave. So family violence leave can be taken by a worker who is a victim of family violence, and it can be used for reasons such as obtaining services from a victim service organization, relocating due to the family violence, participating in civil or criminal proceedings, or seeking medical care or psychological care. So with family violence leave, there are up to 12 days per calendar year permitted for either job protected leave or income replacement benefits. That's a little bit different because for the most part, there's up to 12 weeks available for most reasons, but family violence leave is up to 12 days. Then there are two types of leave that pertain to the military. One is qualifying exigency leave, and that is leave that can be taken when a person's spouse, child, or parent is notified of an impending call to active duty. So that can be used to address issues that may need to be taken care of before that spouse is deployed. So for example, perhaps that spouse was providing the primary source of childcare for the couple's child. They might need to take some time to make other arrangements, or perhaps they need to get some financial things in order or visit their attorney. Those would all be qualifying reasons. And then military caregiver leave is caregiver leave, but it's taken by an employee to care for a military member that was injured during active duty in the armed forces. Military caregiver leave can provide up to 26 weeks of job protection and up to 12 weeks of income replacement. Now, there's a special note that we want to make you aware of for caregiver leave. Excuse me. So under the Connecticut law, an employee can take caregiver leave and receive paid leave benefits for these following relationships: parent, spouse, son or daughter of any age, sibling, grandparent, grandchild, or an individual related to the employee by blood or affinity. What does that mean, related by affinity? So that refers to any person with whom the employee has a significant bond that is like one of the family relationships listed, regardless of a biological or legal relationship. So it's situation specific, of course, and it's governed by the circumstances of those involved. But here are a couple of examples. Say there's an aunt or uncle who relies on the employee for unpaid care, and they have a strong relationship like you would see between a parent and a child. That could be considered relationship by affinity. A very common example might be an unmarried couple who live together and have a familial spouse-like relationship. So they share a home, maybe they have kids together, they share finances, but they're not legally married. And so Connecticut does not have common law marriage. So without this relationship by affinity clause, these individuals would not be able to take time off to either care for each other or be there for each other without this. But under that relationship by affinity, they would be able to do so. So let's take a look at the eligibility requirements. And we have listed here the eligibility requirements for federal FMLA, Connecticut FMLA as it will stand in under a month from now, and Connecticut paid leave benefits. Keep in mind, again, at the risk of sounding like a broken record, the first two columns, the FMLA, refer to job protection, while the column all the way on the right refers to income replacement. So federal FMLA is not changing, and federal FMLA only applies to employers with 50 or more employees. So if you don't have 50 or more employees, this information does not pertain to you. Federal FMLA, in order to be eligible, a person must have been employed by the employer for at least 12 months and worked for at least 1,250 hours. Under Connecticut FMLA starting in January, they must have been employed for at least 3 months and there's no hours worked requirement. Now, for Connecticut paid leave benefits, the person must have earned at least $2,325 in the highest earning quarter of the first 4 of the past 5 quarters. That can be from more than one employer. So if you have an employee who works part-time, as long as their income from you and their other employer or employers adds up to $2,325 or more in that time period, then they would be eligible. And then they also must either be currently employed and working in Connecticut, or they must have had they had been employed and working in Connecticut during the 12 weeks immediately preceding their leave. For Connecticut paid leave benefits, the residency does not have any bearing on whether someone is eligible or not, except in the circumstance of sole proprietors or self-employed individuals. Sole proprietors who have opted into the program must also be Connecticut residents. Now, a review of the summary of entitlements. So for federal FMLA, as well as Connecticut FMLA, there's up to 12 weeks in a 12-month period for all leave reasons, except for military caregiver leave, in which both the federal and the state laws provide up to 26 weeks. So that's for job protection. Under Connecticut FMLA, there's up to 12 days in a calendar year that can be used for the Family Violence Leave Act. And there may be the additional 2 weeks for incapacitation during pregnancy. For Connecticut paid leave benefits, it's essentially all the same as the Connecticut FMLA laws, with the one exception that there are 12 weeks in a 12-month period for military caregiver leave as well. So someone who's on military caregiver leave may be eligible for 26 weeks of job protection, but only 12 of those weeks could be paid under Connecticut paid leave. So that's a lot of information. How does it all work together? And for that, I'm going to turn it over to Kathy, and she will talk through the process of implementing all this. Kathy?
Perfect. Thank you, Jessica. Just a couple housekeeping items before I get started. I know there's a lot of information to absorb this morning. At the end of the presentation, everyone will be receiving a hard copy of this presentation by email. So it'll be a great reference tool. And also keep in mind, if you have any questions regarding what we covered today, there is a section on the Connecticut Paid Leave site, and it's to the right of the first page called Contact Us, where you may be able to submit emails with questions on anything that we may have covered today. So thank you. Next slide, Jessica. Okay, responsibilities for Connecticut paid leave claims. Everyone has a piece of the puzzle here, and all the pieces together make a smooth process for the claims processing. The employee or worker needs to submit the application in a timely fashion. What we mean by that is the employee is required to submit a claim 30 days before they are going to start their leave of absence. The worker will go to the Connecticut Paid Leave website. They need to well, first of all, they need to register, which is basic information, name, address, email address, contact information. Once they create that CTPL account, there will be a pop-up to ask them if they would like to proceed forward and file a claim. And that pop-up will take them to the AFLAC portal. AFLAC is our third-party administrator for the Connecticut Paid Leave claim administration. It will ask the employee questions such as supporting documentation, update their account with absence information, and they will ask also, there will be questions about salary information. It is very important for the worker to notify the employer about the Connecticut Paid Leave claim. Now, just as a footnote, when a claim is approved, the employer will receive an email indicating that one of their employees, that'll have the name of the employee, the type of leave that they're taking, and the dates, the beginning and end date of their leave. So as part of the process, I'm going to move down to employer. The employee will be providing their employer with a copy of what is called an employment verification form. The employee receives this as part of their package when they submit a claim. On that form, it will be asking the employer to validate the absence dates, hours, and hours worked, scheduling. And once you complete that form, you can either fax it or email it over to AFLAC for further processing. So that would be also a great opportunity when the employee comes to you and gives you this form. Take that opportunity to discuss with them any paid time off, any short-term disability policies you may have in effect, and any other conversation you may want to have with the employee regarding benefits or payroll. So the Connecticut Paid Leave Authority with AFLAC, AFLAC will determine the eligibility for the claim based on the information received. They will calculate and pay the benefits and monitor the claims on an ongoing basis. So let's say someone decided to take a 2-month Connecticut paid leave, they were approved, and now all of a sudden the doctor says, okay, you could go back to work after 5 weeks. So that would be reprocessed, and another email would be sent to the employer saying, okay, these dates have changed. And there's a monitoring on an ongoing basis for any changes that may happen during a claims process. Connecticut Paid Leave Authority, in alignment with AFLAC, will investigate potential fraud, if there is any, and impose penalties as appropriate. Now, claims, when they're approved or denied, an employer will receive an email. So it's very important when you submit the employment verification form that you put a contact email address in addition to a phone number, just in case we need to reach out to you. Let's say a claim is denied, perhaps for insufficient documentation. The employee is able to go back to AFLAC and request a reconsideration. Sometimes if they need like a medical certification and the physician is out on vacation for an extended period of time, that's just like an example of perhaps why something may be denied. And if for appeals, like say someone has a claim denied and it's determined that is truly denied, the Connecticut Department of Labor will be hearing appeals related to the denials of claims and any penalties. Next, okay. Income replacement benefits, Connecticut paid leave process. The worker goes online, activates the portal, sets up their account, submits the application and supporting documentation. They'll be asked questions for the reason why they're taking the leave, how long they plan on taking the leave, and other job and income information. AFLAC will determine the eligibility based on the information received, and they also have DOL data that they have access to validate the worker's salary and the information on the application. And if it is determined that the worker is not eligible, AFLAC will notify the worker and give them the information to request reconsideration. If the claim is approved, the AFLAC determines if the claim is approved with the supporting documentation. If anything is missing, they will reach out to the worker and say, hey, we need this additional documentation you forgot to add to the website. And then they go through the entire claims process. Okay, AFLAC calculates the benefits that an employee will receive while they are out on leave. They use the Department of Labor data and other sources of info necessary to calculate base earnings. They take into consideration the type of leave and any offsets of income, such as paid time off or short-term disability payments. The payments are issued either direct deposit by electronic transfer, or the employee has the option of a stored value card, otherwise known as a debit card. Benefits are issued every Tuesday. That means the payments are going out every Tuesday, and they are paid 2 weeks in arrears. So for example, someone applies for a claim this month, because employees can apply this month, but the benefits are not effective. Benefits are not effective till 1/1/22. So let's say someone is approved for January 2nd through January 8th. Their first payment will be received on the 18th. So that's just something to keep in mind, that the benefits are paid 2 weeks in arrears. Oh. If there are any changes to their leave, say they need to take a longer leave, they need to go take less time, all of a sudden they received, they were approved, say, for short-term disability. Any changes related to a worker's Connecticut paid leave, they need to notify AFLAC, and that information is communicated to the employee or to the worker. Okay, Jessica. All right, this is an example of what the employment verification form looks like. This is a sample. Well, this is the form that the employee would be bringing to you to say, please fill this out and then get it to AFLAC. As you can see, the top portion of the form is what the applicant, the employee or worker would complete. And then there is the employer section. I'm looking for, there should be, Jessica, the phone number and email address for AFLAC. I see it's not on here, but we'll take care of that.
Yeah, it actually is on the form. This was an earlier sample and we had redacted the information so that people didn't send it in prior to the December 1st.
Yes, perfect. Okay, so just to let everyone know, under the employer information, it says instructions to the employer. There is an email to send this completed form to AFLAC, so you could scan it and then email it to them. And in addition, there is a fax number. So we would be looking for employer name. And when it comes to the tax IDs, you really only need to fill out the federal employee ID number, which is the FEIN number. You don't need to put in a tax ID or the SIC. It's important that we have the FEIN. The address of your business, contact information. You have the option of email or receiving information by letter, but with postal service delays, I would highly recommend email. You'll know a lot faster about the results of a claim, your contact phone number, and then a contact email. This contact email, I would say, is the most important piece of information besides the FEIN number, so that once a claim is approved, if it's disapproved, if there are any issues, this is a way that we can immediately and rather quickly reach out to you and solve any issues that we may be experiencing.
Kathy, while we're on this slide, someone asked a question: is the communication between employers and CTPL via email not using the online portal? Could you answer that?
Not using? Okay, let me see.
Yeah, so all communication between Connecticut Paid Leave and the employer will be through email, correct? There will not be an online portal option.
No online portal option, no, for employers, no. It's all email, yes.
Okay, and another question that just was put in the chat: what if an employee cannot apply 30 days in advance because it's an urgent situation? The 30 days in advance really applies to foreseeable situations. Yes. So someone knows they have a scheduled surgery, something like that. If it's an urgent situation, we ask that they would apply as soon as is possible and practical.
Correct. I mean, if it's an emergency, something, someone's in a car accident, something happens, of course, you do it as soon as possible. This has happened in the past under FMLA and Connecticut FMLA, where, say, something happens on Monday and you find out today, we just work with it. We make any adjustments to, payments, or we'll probably spend the first portion of the time gathering all the information together from the employee. And if they're not in a position to do that, hopefully they'll have a family member or someone that would reach out to us to say, hey, this is going on. And then at least we can do some type of outreach by mail or by phone to the home.
Thank you. Let me advance for you.
Okay. So this is the fun part. Early Wednesday morning, we're going to be doing some math. Benefit payment calculations. I like this example because it's a lot simpler, believe it or not, than a slide that we had previously. If a person makes minimum wage, the benefit is 95% of their base weekly earnings. So right now, the minimum wage is $13 an hour. And let's say someone works 40 hours a week. That comes to $520 weekly. We take 95% of that benefit. 95% of 520 is $494. So worker A receives $494 in benefits. Okay. This is taxable income. So in their welcome kit, when they complete all the required documentation and they have communication with AFLAC, they will have a tax form in their welcome kit that they need to complete. If a worker earns more than minimum wage, the benefit is, okay, it's a two-step calculation. It is 95% of 40 times the minimum wage. In this example, 40 times $13.50 is the $540. Then there's a second portion, 60% of the worker's base weekly earnings minus Connecticut minimum wage multiplied by 40. What that translates to is, in this example further down in the column, 95% of 40 times 13 is your $494. And then the 60% of the $540 minus $520, which is $12, and gives us a total of $506. So these are just examples of how we calculate the benefit payments. If an employee ever has a question on, I don't understand this, how is this calculated, they need to direct their questions to AFLAC. Anything about eligibility, benefit payments, you know, I didn't get my payment, I didn't get my direct deposit, that is all directed to AFLAC. Okay. Okay, now the good news is we do have a benefits estimator at the ConnecticutPaidLeave.org site. What benefits may I receive? So you can put an estimated number, or the employee can put an estimated number, or the employer can put that in there because you want to know, for payroll purposes, what do you think this person may receive? So you select the pay period frequency. Is it weekly, biweekly, monthly? Enter the gross earnings, and then you're going to get the benefit estimate. Okay, so we have a few scenarios here that we put in the presentation to help you with different examples of what may occur with employees on leave. So scenario number one, let's say an employee, a worker comes to you, they have no PTO. So they don't have any PTO, they apply for benefits, they get approved. The worker will receive the full amount of Connecticut paid leave on day one when they start their leave. So that's pretty clear cut. Scenario number two, the worker has enough PTO to cover the entire leave. So let's say, you know, we've had employers who have very generous PTO time. And let's say a worker is out of work for 4 weeks. And the employer says, okay, you know, part of our benefits package, we pay you 100% for the 4 weeks you're out. The person wouldn't be receiving any Connecticut paid leave benefits because they're already receiving 100% of their pay from their employer. Okay. Scenario number three, the worker has PTO to cover part of their leave. So this is some of the information that the employee would be providing AFLAC during the claims process, and also information that will be asked of you, the employer, on the employment verification form. So Connecticut paid leave benefits start after the PTO is exhausted. Now, for Connecticut FMLA, starting 1/1/22, as Jessica had mentioned earlier, let's say an employee has 4 weeks vacation. Under Connecticut FMLA, by law, you're required to keep 2 weeks of the employee's time off for 2022. Okay, that's Connecticut FMLA. That's not Connecticut paid leave. Scenario number four, PTO pays less than the worker's regular pay. So let's say the worker's approved for 1/1, and now they don't have enough PTO time to, you know, fall into one of the other scenarios. So then there would be a coordination of efforts between Connecticut paid leave and the employer for the assurance that no employee will receive in any scenario more than 100% of their regular pay. We don't want that to happen. But there will be a coordination of efforts between AFLAC and the employer. And if AFLAC has any questions, they could email you directly. Okay. So what do your workers need to know? When you have an employee coming to you saying, I applied, they can either tell you before or after. Hopefully employees will notify their employers prior to taking a leave. So when they come in and they tell you they're going to take the Connecticut Paid Leave Program, that would be an excellent time to provide them with information about their PTO, about short-term disabilities, short-term disability payments, if they're eligible, and if there are any rules about using the time off. Also, if you do offer a short-term disability policy, my suggestion would be to review it at this time. Workers and employees are eligible to file claims during the month of December. The claims are not for December. The claims are for 1/1 moving forward. Payments are going to begin 1/1 moving forward. So I would review your short-term disability policy just so that there's an understanding, if you have one, as an understanding as to what's covered, when it's in effect, what steps you need to take to coordinate. And if I just got a pop-up. And if short-term disability policy will reduce the Connecticut paid leave or any other PTO time or any other funds that the worker will receive. Okay, implementing Connecticut FMLA claims. Again, this is Connecticut Family Medical Leave Act. This is different than Connecticut Connecticut paid leave. Okay, so the worker needs to notify the employer they're going to take time away from work. They submit their application. They provide the employer with supporting documentation, and they comply with the employer's attendance and call-in policies. One thing employees would need to know is, what is your current policy when they're out on leave? How often do you require them to call in? Do they call in to the supervisor or manager? And then does the manager reach out to HR or the owner of the company? So those are things that if they're not established, I would recommend that they be documented so that there's a consistent and clear policy for everyone to follow. So the employer would establish a leave policy, including the rules about paid time off usage, post the FMLA poster, process the leave requests, and monitor leave usage. This is something that I've seen companies do on Excel through their payroll, in coordination with payroll, in coordination with the manager. Most of the time, your immediate supervisor or manager would know about the employee being in and out of work or any changes, sometimes before the employer or say the HR department would know if you have one. They would manage the worker return to work. And an important note for all employers, please refrain from discriminating or retaliating against workers for family medical leave usage. Now, Connecticut Paid Leave Authority. We're providing you with this Connecticut FMLA information, and Jessica has provided the federal FMLA information, not because we administer those programs. We only administer the Connecticut Paid Leave Authority, which is going into effect 1/1/22. We provide this information as part of the Connecticut Paid Leave training. Okay. Connecticut Department of Labor handles the Connecticut FMLA, and they provide guidance to workers and employers about Connecticut FMLA. Jessica, is the website on this, is the Connecticut Department of Labor website on one of these slides, or is it at the end?
I'm not sure if it is,
Okay.
but I will put it in the chat for everyone.
Okay, thank you very much. So there is a Connecticut Department of Labor website. If you do have questions on the Connecticut FMLA, you can reach out to them, and also about the federal FMLA. If you have questions or concerns, you can go to the Connecticut Department of Labor website that we will be providing you. Okay, so again, this is just an overview as to what happens with the federal family medical leave. The worker notifies the employer they need time off. And please note, the worker doesn't need to call it FMLA, but it is if they're going out on a leave. 30 days in advance, if foreseeable, and as soon as practical if the leave is not foreseeable. The employer determines if the worker is eligible for Connecticut FMLA. And this, if you need help with, you can reach out to the Department of Labor. They're responsible for the Connecticut FMLA. They can help you answer questions and provide any additional documentation. The employer has 5 days to notify the worker of their eligibility and provide what's called a notice of rights and responsibilities. Please note, this is not the leave approval. Okay, the worker provides the required documentation, which is the medical certification from the physician. In the case of adoption, any adoption documents, court dates, military records, or whatever is required for the leave. The worker has 15 calendar days to provide this to you, the employer. If the employee has any difficulty obtaining documents, the employer should give the worker additional time. Once the employer notifies the worker that the leave is approved under Connecticut FMLA, you as the employer have 5 business days to process the required documentation supporting the leave. And then at that same time or shortly after, notify the worker if they're required to use any paid leave accruals, how the worker needs to report in, what are the expectations from the employee, from the worker once they're out on leave. The worker reports to the employer when they take the leave, and it's the employer's responsibility to track the leave so the worker does not exceed the 12 weeks. Once the worker returns to work, they have the right to return to work to the same job with the same terms and the same conditions. An employer cannot insist that the employee be 100% fit for duty or totally recovered. Employer must consider ADA and CFEPA obligations. Okay, complicating factors for managing FMLA. Managing worker absences. Setting up policies and procedures as to how you're going to monitor the 3 different types of leave. There's a Connecticut Paid Leave Authority, there's a Connecticut FMLA, and then there's the federal FMLA. So, you know, setting up procedures internally for your company is very important to get all this straightened out before things really start. I would say, you know, when employees start increasing the submission of claims for 1/1, when benefits start getting paid after January 1st, we anticipate that there will be more claims. So one of the things, documenting and enforcing an attendance call-in policy. If you don't have one, I would say, you know, have something documented, because whatever documentation and preparation you do ahead of time will only help you and streamline the process as you move forward. Timely notice from the supervisors and the employees about absences. You know, write up a policy as far as what is that requirement. Managing intermittent leave due to unforeseen circumstances. Let's say an employee is approved for intermittent leave and it's 2:45 on a Wednesday afternoon, and they're like, you know, I don't feel good, or, you know, I have a headache, or whatever it is. They could say, you know, I need to take 2 or 3 hours of intermittent leave this afternoon because I'm not going to make it through the day. So managing intermittent leave is probably one of the most difficult parts of any of the 3 leaves to manage. And that a lot of times falls on the immediate supervisor and or immediate manager. Calculating the average work week for workers who work fluctuating work weeks. So people who have, not a set schedule, they may work 20 hours one week, 30 hours another week. It just adds additional documentation on your end as an employer to keep track of all this. Incomplete or insufficient medical certifications, that's not anything you really need to worry about as an employer. However, when the employee completes the claim forms and they're trying to get their claim approved, let's say the doctor forgets to sign the medical certification. Well, now AFLAC has to reach out to the doctor and, we need to have them sign it. And if, we need to have that signed in order for the employee to go out on their leave. And managing Connecticut FMLA, federal FMLA, and CTPL is going to be a little challenging for those who are not familiar with all these different leave administrations. Just a note, sometimes workers may come to you and say, I just want time off. I don't want it designated as FMLA. In all circumstances, it's the employee's right and responsibility to designate the time off that qualifies as FMLA, even if the worker doesn't say, I'm taking FMLA. So that's something to keep in mind. Okay, overview of leave laws. Here are just a few, here is a list of the different leave laws that are in effect. Federal FMLA applies to employers with 50+ employees. Connecticut FMLA, before 1/1/22, that means currently, it applies to employers with 75 or more employees. Effective 1/1/22, it applies with employers with 1 or more employees. There's also workers' compensation. Something to keep in mind, if an employee is on workers' comp, or for some reason, if an employee receives unemployment insurance, they are not eligible for Connecticut paid leave. Those questions are part of the process when the employee is applying for the claim for any leave for under Connecticut paid leave authority. And I do believe that question is also on the employment verification form. It will be asked of you as an employer. So let's say, for example, someone applies for a claim today, and they're in the process of applying for workers' comp. Workers' comp gets approved for January 1, and let's say they applied for Connecticut paid leave and they got approved, they're not going to get paid from both. We have an auditing process in place, and we are working with the Department of Labor to ensure that there are no duplicate payments in those other agencies. American with Disabilities Act, Pregnancy Disability Act. I think that's my cue to hurry up.
I'm sorry, Kathy.
I thought it was like the lights dimming in the theater, like time to go. Connecticut Fair Employment Practice, 3 or more employees. Connecticut Paid Leave Act is effective 1/1/22. Workers' comp for on-the-job illnesses or injuries. And I turn it over to Jessica because I know she's anxious to do her next part.
I'm sorry. I really
Don't
apologize.
worry.
I need some more coffee. So we want to leave you with a couple of additional resources. On our website, there is an employer toolkit and also a human resources toolkit that you can download that has more information about many of the topics we've talked about. And there's also an employee rights poster, an employee fact sheet, paycheck inserts, etc. And we're constantly adding new information. If you have questions, we really do want to make sure that we can help answer anything and everything. We do not have a call center because our sole source of funds is taxpayer money, and call centers can cost upwards of several $1 million per year to operate. So we do have a contact us portal on our website where you can submit your question. You can choose either that you would like a response by email or by phone. So you can speak to someone, we just don't have an inbound call number. We also have a frequently asked questions section on our website with several hundred questions that are being updated on a weekly basis. And on our YouTube page, we have many helpful videos, including videos for how to create an account and how to submit a claim. So if you do have workers coming to you and asking questions about that, you can direct them to those videos. So with that, I know we're just about time, but we did have a couple of questions come in that we wanted to make sure we answer for you. So Kathy, I am going to give the first one to you. If an employee is out for medical leave now and it will continue in 2022, can that person apply for paid leave in 2022?
That is correct. The answer is yes. They need to go on the portal, register, file a claim, go through the eligibility process. Even though they might have been approved under FMLA or Connecticut FMLA for 21, they need to go through the claims process for 1/1/22 under Connecticut Paid Leave Authority.
The next question, can you give some information about intermittent leave, and is there any intermittent pay? How does that work?
Yes, there is intermittent pay under Connecticut Paid Leave Authority. And it all depends on, the medical condition, what the doctor's recommendations are. But we do have what's called block leave, which is continuous, like someone takes, say, 3 weeks of leave. There's reduced schedule because let's say the person works 40 hours a week, but they could only come back to work 20 hours a week for a couple of weeks before they go back to their regular schedule. So we have block leave or continuous leave. We have reduced schedule, and we also have intermittent.
Thank you. All right. And is there a secure email to protect the employee social security number?
Absolutely. When we developed the Connecticut Paid Leave process, when we developed the claim forms, I was heavily involved with IT development, with the forms, everything from soup to nuts. We have a thorough policy in place for fraud, for security. We did a lot of in-depth research on what's called the dark web, where people try to break into people's emails or try to break into, say, the Connecticut Paid Leave system. We have a lot of processes that were developed. Something I haven't seen, I've seen protections put in place that I haven't seen with other softwares. And I would say yes. To answer your question, yes. The social security numbers, everything is protected. It's a secure site. And also on the AFLAC side, we worked in tandem to make sure that the securities were in place.
Thank you. Then the last question, and I'm happy to address it because it actually just came up yesterday on a webinar, so I have some information about it. So someone was asking about Connecticut FMLA, and as we've mentioned, the Connecticut Department of Labor oversees FMLA. We provide information about it because it really is hard to talk about Connecticut paid leave without talking about FMLA, but we really have no oversight of that. So I know someone was asking, are there forms provided by the Department of Labor that can be used? And so the way the process works is new forms are developed and then they're circulated internally with other state agencies for input, and then they're posted for public comment before they can actually be posted to the DOL website. So we learned yesterday that they're in that process of circulating it amongst, excuse me, other agencies. So I know that folks are eager for that information. We understand that, DOL understands that, and so that's where they are in the process. So we don't know an exact date, but hopefully that information will be posted very soon. Someone also asked, what if they have more than 50 employees, but less than 75 with a fluctuating amount of employees throughout the year? And this was the question that came up yesterday. And the answer is that federal FMLA states that if you have 50 or more employees for at least 20 weeks during this year or the previous calendar year, you are subject to federal FMLA. So it sounds like in this case, if the company meets that criteria of more than 50 employees for at least 20 weeks out of the year, they would be subject to federal, and then of course, starting in January, they'll be subject to Connecticut FMLA as well. So I hope that answers that question. And that person also asked if there was a phone number they could call. I would just say, and I know this is probably not the answer you're looking for, but I would call the Department of Labor and see if there is someone that they can specifically direct you to. I would also say that if you are not receiving our newsletters, we do send out frequent newsletters. And when we get that information from the Department of Labor, we will put it in our newsletter. So if you would like to receive the newsletter, if you go onto our website, scroll down to the bottom of the homepage, you can enter your email address and sign up to receive those. And that would be a great source of information for you. And with that, we are at 9:03. I believe we have answered all the questions. Thank you so much for taking the time to join us. We hope you found this information useful. And again, if you have further questions, please use the Contact Us portal. We also have several more webinars coming up. So if you would like to listen to this information again, you're welcome to join. And we have many webinars coming up for workers as well. So if you do have employees that are coming to ask you about the program, if you would like to direct them to join one of our webinars so they can hear the information from us, we'd be happy to have them join us for that as well. All right, thank you so much. Hope everyone has a great day. And again, you'll receive an email in a few days with a link to the recording and the presentation. Thanks, everybody.
Thank you, everyone.